SJC-13877, Claire Fitzmaurice et al. Versus City of Quincy et al.
Okay, Attorney Davis.
Good morning, Your Honors. May it please the Court. My name is Joseph Davis, and I represent the appellants, the City of Quincy, and Mayor Thomas Koch. I'm joined by James Timmons, the City Solicitor, and my colleagues Eric Rosbach and Andrea Butler. Your Honors, firefighters and police officers across the Commonwealth and the country understand the figures of Florian and Michael to symbolize the values of courage and self-sacrifice that they seek to embody in their professions. The City of Quincy does not violate Article 3 of the Declaration of Rights by honoring its first responders with statues of these figures. And that conclusion is confirmed by Article 3's own text, history, and purpose, by this court's precedent, and by the longstanding tradition of similar statues on public property across Massachusetts. And on that last point, as a quick example, on my way into this court's courtroom this morning, I walked by this court's statue of Moses in the Great Hall. Right next door at the Suffolk County Courthouse, there's a depiction of Moses above the main entranceway holding the Ten Commandments. In the Worcester Courthouse, there's another statue of Moses. Why does Moses appear in all of these courthouses?
How many fire departments and police departments in the Commonwealth have statues on the front of the building itself of either St. Florian or St. Michael?
I'm not aware of any others in the Commonwealth, Your Honor.
Right, so that may seem, wouldn't that be part of history and tradition as well, that this would be the first one in the Commonwealth?
Well, Your Honor, I do want to point out that a number of fire departments, I mean, the majority of fire departments across the Commonwealth use the Florian cross as part of their symbol.
Okay, but I didn't ask that question. I understand. I saw that in your record, that they're badges, but we're talking about these actual religious figures as statues on the front of the buildings, and they're, I take it they're just none others in Massachusetts.
Well, I would dispute that their religious figures are at least exclusive.
Okay, Florian and Michael. Just call them Florian and Michael. I take it that there's not another fire department or police department in the Commonwealth of Massachusetts that has these as statues on the front of the building.
There's the Los Angeles Fire Department, the New York City Fire Department, the Bristol, Connecticut Fire Department, New York City Police Department, Bristol, Connecticut Police Department.
Okay, so none in Massachusetts, and you've come up with 3 out of the probably hundreds of thousands of police and fire department buildings in the country.
Your Honor, I do want to draw...
And I don't mean to quibble about the numbers. I'm just trying to, you started off by saying the history and practice in this Commonwealth. And that piece of it is part of the history and practice, right? This absence.
I mean, I think, I'm not sure, Your Honor. I want to draw an analogy, right? Because the reason that the Moses statues are relevant, and there's a number of other statues, obviously we've identified a bunch in our brief, pages 29 through 69 of volume 2 of our appendix. The reason the Moses statues are relevant, I think, is that Moses is obviously a figure that has religious significance for lots of people, for practicing Jews, Muslims, and Christians. But the reason that he appears in courthouses is because over time he's come to take on a broader significance as representing law and the legal profession more generally. And I think something identical to that, something precisely analogous to that, is going on at the Public Safety Building in Quincy. The reason that these figures are being proposed for the building is not because of their religious significance. They do have that, although not only for Catholics and Christians, I would add. But the reason that they're being proposed for the building is that over time they have come to take on a broader significance as representing firefighters and police officers more generally. And you don't have to take that from me.
Can you understand that significance without reference to their, I'll just call it hagiography?
So I would encourage you, I mean, you don't have to take this from me, Your Honors. You should take it from the firefighters and the police officers themselves. So in this case, you have before you amicus briefs filed not only by Quincy's own fire and police unions, but also by the 3 largest organizations representing firefighters and police officers in the country. And that's the International Association of Firefighters, the Fraternal Order of Police, and the National Association of Police Organizations. These are secular organizations, obviously. Together they represent, I think, nearly 1 million firefighters and police nationwide. And they've come before you and they've told you, like, yes, like the city of Quincy is right about this. These are the symbols that represent us. They have a significance that transcends religious lines, and they really do embody the core virtues that firefighters and police officers seek to display when they go to work every day. And so, I mean, I think that's the reason they would go up on the
But
building.
rather than zooming out to that, why don't we just focus on this case?
Yes, Your
So in response to Justice Wolahojan's premise, you said that you would push back on that these are religious symbols or I forget what the phraseology, but if you look at the contract language commissioning the statues, it says St. Michael, the archangel, the patron saint of law enforcement, and St. Florian as protector of the firefighters. So why is that not contemporaneous evidence of a religious purpose or effect?
A couple of reasons, Your Honor. I think the first, most narrow reason is that I don't think the record even reflects where that language came from or who it's really attributed to. So it seems like kind of an odd thing to latch onto to try to delve into the decision maker's heart of hearts or something like that. But I do want to. I mean, the city is not disputing that those are the names of these figures, or at least how they're often referred to. But I don't think that really. I don't think that really contradicts my point, Your Honor. I mean, for example, on the Boston Common here, there's a plaque called the Papal Mass plaque that's about Pope St. John Paul II. And it obviously calls him that when it's saying, who the plaque is about. Moses is depicted holding the Ten Commandments. That's, of course, his traditional religious iconography and also non-religious iconography. So I don't think referring to them by common names is really all that dispositive.
Well, it's important because if the idea, and you go back to the amicus briefs that have been filed, if these statutes inspire first responders, and that depends on their traditional roles as protectors of firefighters in the police, is the city asking us to separate the secular kind of professional meaning of that from the religious intersection that gives those symbols their force? I mean, that's what gives them the force, right?
So, Your Honor, I don't think it's so much about separating. I mean, I don't want to keep going back to the well too often, but why is Moses associated with law and the legal profession? It's because, he's understood as having been a lawgiver, on Mount Sinai. So it's not about separation. It's about taking on a broader significance, Your Honor. And, another example, in the Boston Public Garden, there's...
a good example, why don't we start with Colo? Colo has... The chaplains are giving a prayer or some kind of admonition to start, and we said that was okay, even though it was clearly had a religious component to it. So that's your best argument, right? Not that it's secular. I mean, it's a mixture of secular and religious, and Colo seems to struggle pretty intelligently with this, although we've got the women's stuff, but. Colo says we look to history and purpose, then we can't provide less protection than the feds, so it provided the federal test at the time. So isn't Colo a good starting point for how we go about this? And
Absolutely, it is, Your Honor, and you're correct that this court, of course, never disputed that the prayers had a religious nature. They were, prayers delivered by Catholic priests, so that would be almost a nonsensical thing to try to say. I think Colo is binding law. I mean, it's got the lemon stuff, as you say, Your Honor.
I'm trying to figure out what in Colo, because Colo is a pretty comprehensive decision. It doesn't just apply the Lemon test, and it provides cautions. It seemed prescient that Lemon was going to have some problems with it. So we start with purpose and history. There's also some sense even in that history evolves in Colo. So isn't Colo where we start with some modifications to Lemon? I'm just trying to figure out the law we're applying here.
Yes, Your Honor. We've proposed text, history, and purpose, which is this court's ordinary methodology when it's interpreting the Constitution. But I think Colo is fully consistent with that. And I agree with you, Your Honor. I think you could track Colo up and down. So where does Colo start? It talks about, what was the First Amendment, and then also the provisions of the Massachusetts Constitution. What are the kinds of things that they had in mind? What were the abuses that were going on at the time? Here, I don't think the plaintiffs have identified a single example of sort of religious imagery or mixed imagery that was on anybody's mind at the time that Article 3 was.
Your articulation of text, history, and purpose frightens me, and it seems brewing-like. Can you Is that what you're proposing, that we go?
No, Your Honor,
the
it's
Bruin
Barron
test
versus
cause us-
Colinda-like.
cause
It's Barron
us
versus, I'm sorry, I didn't mean
Lots
to
of
talk.
concerns?
I'm sorry, I talked over you.
Yeah, distinguish your text history and purpose from what SCOTUS has done in Bruin.
It's not Bruin-like, Your Honor. It's Barron versus Colinda-like. So, I mean, our basic point is that obviously, you know, the text of the Constitution is a starting point. But I think history matters, and Colo explains how history matters, right? So as I was just discussing with Justice Kafker, Colo walks through the history of the framing of the First Amendment, and then, you know, we would say you should add the Article 3.
It goes through our history.
It goes through our-
history. We start with a constitutional provision that allowed basically money to be taxed to support one sect. And then we said, okay, we're moving away from that. And Colo has language about history. Certainly the degree of intermingling of religious and secular life was much greater at the time the First Amendment was being debated than it is today. So it may not do Klinger-like, modernization, but it contemplates change, doesn't it?
I think it does, Your Honor. We're not trying to say that anything, you know, any development should be off limits for this court. I mean, I think the upshot of, you know, plaintiff's argument about taking into account modern developments and saying that this is a religiously diverse Commonwealth. I mean, we would agree. And we would say that the upshot of that ought to be for courts to not be, you know, policing public symbolism for, you know, its alleged religiosity. I mean, within the limits of Colo.
But is there some element of sectarianism in this, though? Because that clearly was on the mind of our framers, right? And eventually, at least in 1833. So is there an element of preferring one religion here that we should be concerned about?
No, Your Honor, there is not. And that's true not only because these figures...
Why not? Because these are two Catholic symbols. Does that heighten our attentiveness to this?
Well, Your Honor, they're not only Catholic symbols. I think that's quite
I get that they're not only, but they're, at least originally, they're saints because the Catholic Church made them saints, right?
I think within so I won't keep pushing my points about their broader significance. I'll talk about within the world of religion, right? What you actually have before you also, you know, briefs from the Muslim perspective, from a Jewish perspective, from a Russian Orthodox perspective, saying that we also care about these figures. I mean, Florian is a figure of history who, you know, the legend says he put out a fire. So it should be not all that surprising that firefighters would think that this is a...
But the fact that there are more religions doesn't seem, who recognize these as religious figures doesn't seem to me to advance the notion that they're more secular.
So, right, I was trying to distinguish between those two different ideas.
Right,
Your Honor.
so it's like, oh, it's even more religious doesn't make it even more secular.
No, I would say both are true, Your Honor. These figures have a mixed significance, a broader significance than just a religious significance. They've come to represent firefighters and police officers, whatever their beliefs or background. But even if you focus on the religious part of their significance, which we haven't disputed that some people might view them as religious, even within that narrower focus, they're not exclusively associated with one tradition or
Is
another.
the new building going to be the only police and fire department building in Quincy?
It is the new public safety headquarters. I think that's probably true, although, you know.
Okay, so the headquarters will be, and this ties into Justice Kafker's question and at least in my mind, which is if this is, you know, the police department and the fire department headquarters are places that will provide necessary public services. And so the citizens of Quincy will need to use that building, will need to have access to that building. And in that context, why doesn't it heighten our concern about this government speech that's embodied in the two statutes?
I don't think it differentiates this building from courthouses, for example, which of course citizens need to use. And I do want to say, I think this would be a significantly different case, obviously, if there was some allegation of differential treatment based on anybody's beliefs.
Well, this is a problem for you because downstairs there are 18 or 16 statues. Moses is one. and they're all law related, so that there's a context. But these are going to be the only two statutes.
Well, I mean, I wouldn't say that's invariably, so you're right about the Great Hall, of course, Your Honor. I don't think that's invariably true. The Worcester County Court House, I think it's more of the standalone variety. But I think the context that matters here is that this is the fire and police building, and these are the figures that represent firefighters and police officers. So if these figures were put in, a more random location, I could see how that would be troubling. But I mean, as I said, the 1 million firefighters and police officers are coming into this court and affirming that we represent people of all faiths and none, and these are the figures that embody the virtues they seek to display. On the Colo point, I do think it's kind of a rich irony in this case that plaintiffs are presenting this case as a choice between our approach on the one hand and Colo on the other, because we would say Colo absolutely supports us and is in fact consistent with our analysis. I mean, you run through Colo like we were doing earlier, even on the purpose point, right? Colo says, what are the secular purposes that are served by legislative prayer generally? It's not sort of an effort to dive into what was going on with the legislators that crafted the chaplaincy statute.
Can I ask you, we're here on a review of the preliminary injunction. And you're, you in the Lemon test or Colo test, the first is the secular purpose, but here the judge found that the purpose was not secular. What do we do with that in light of our limited role in reviewing the preliminary injunction?
No, I think that's an important question, but the
I thought so.
Yeah, the judge. The judge, I think he didn't actually make a fact finding about what was the purpose behind these statutes.
Just didn't believe the mayor.
He didn't believe the mayor, which
and used McCarthy's statement,
which we find troubling. We have a sworn affidavit, of course, that has never been crossed.
Was there an evidentiary hearing, or it's all done on documents, right?
It's all done in documents. The plaintiffs didn't ask to cross-examine the mayor. But I want to focus on what the Superior Court did say, which is that basically based on the religious nature of these statutes is how he put it, that they lacked a secular purpose. And I think that's a legal argument that's squarely contrary to Colo. I mean, what Colo explicitly says, these prayers have a religious nature. Of course they do, right?
No, don't we defer to his finding of a likelihood of success on the merits for PI?
I mean, not if it's based on a legal error, Your Honor. I mean, if it's based on a legal error, that's per se an abuse of discretion that's justified vacating the preliminary injunction. And I do think it's a legal error under Colo because, again, Colo says there are secular purposes to legislative prayer generally. It's not like what was going on in the legislators' hearts that crafted the legislative chaplaincy statute. It was these prayers serve to solemnize government proceedings. And it's a highly analogous purpose to the one served by these statutes. They serve to solemnize.
You're saying it's a legal error, but what Judge Sullivan ultimately says is, I discredit the mayor's affidavit.
He doesn't say that, does he?
Well, at least as to the part about what the basis was for the religious basis for choosing the statute.
I don't think he says that, Your Honor. But even if he did, our point is that
he said his statement is self-serving, right? He didn't say he didn't believe him. He said it was. I don't know what, but we're in the same position to evaluate those affidavits. Justice Gaziano's question is a good one. How do we analyze reasonable likelihood when it's on documents?
You're in exactly the same position that the Superior Court was in to evaluate this affidavit. It's not like he was making a credibility determination based on having seen the witness or something like that.
Our case law would suggest otherwise.
Well,
that trial judges do get to pass on the credibility of affidavits, and we say this in the context of motions for new trial all the time, that self-serving, he doesn't have to credit that. But let me ask a more pointed question about that.
Yes, sure.
Aside from what you filed in front of Judge Sullivan with the mayor's affidavit, was there any other evidence that was presented to Judge Sullivan in making that determination about whether the city considered any other non-religious alternatives or selected these figures through some kind of public process rather than them just being the patron saints of firefighters and the police?
I mean, the evidence as to the mayor's purpose and thinking was totally one-sided at the Superior Court. I mean, his evidence, or his contemporaneous statements before the affidavit were exactly the same as what he said in the affidavit. We had the firefighters and the police, his point was, I'm putting these up for the firefighters and the police officers because these are symbols that represent them. And then you had the firefighters and the police officers come into the case, try to intervene and say, yes, he's right, these symbols represent us. So it really is,
But there's also the clandestine nature of what the mayor did. And that figured into Judge Sullivan's analysis that it wasn't done publicly. It was done sort of secretly.
Well, I mean, we would dispute that. Those adjectives, obviously, Your Honor. I mean,
Clandestine's not accurate?
well, it was done, I mean, I guess that sort of has a connotation to it that, I mean, it was done late in the process because this building was built according to the construction manager at risk process, the whole point of which is to allow flexibility. So there's no doubt that, the mayor testified. It was as we were finalizing the facade of the building that we realized there's room in the budget. We like public art and we'd like to put some public art.
Any
up in this building.
precedent for a major piece of public art being done like this? Usually there's tons of process, right? Art is controversial in general, right? People have strong views. That's got to be a factor to consider, isn't it?
I mean, if you had a procedural claim, something like that would be a different case. It might be a really interesting case, but I'm not sure what the upshot of all this is for the Article 3 question, because even if to our colloquy earlier about the affidavit, assume that the judge did, dismiss the affidavit in whatever way that this court would defer to. I'm not sure that's correct, but you're still left with, do these statutes, do they serve secular purposes as a general matter? That's what the COLO question is. The COLO question is not what was in the head of the people who crafted that statute, that legislative chaplaincy statute, here selected these statutes. Instead, it's do these statutes serve secular purposes generally? And I think the answer is yes, based on what the firefighters and the police officers have told you. And I really think you would have to do one of two things in order to rule against Quincy here. I think you'd have to either say, number one, the firefighters and the police officers are just wrong, and that these statutes really are just religious.
Well, is that really the aperture, though, or is it what's in front of what was in front of Judge Sullivan? What Judge Sullivan's decision is based on is what we're looking at. Do you have all of that in front of him?
Well, he did, Your Honor. So he didn't have he had one out of the 4 amicus briefs that I was running down earlier, but he also had all the evidence that underlies those amicus briefs. The city put in evidence about the Floridian cross in fire department logos.
Can I ask you how we measure the perception on the secular part of it? So if a citizen of Quincy is driving down the road and sees it, and they see this big angel smiting a demon, and someone has to explain to them, oh, that's actually the symbol, that's St. Michael, is the symbol of good versus evil in police departments. Isn't that kind of a niche explanation that when you see this immediately, it strikes as overwhelmingly religious?
Well, Your Honor,
you have to crane to see that St. Florian is actually holding a pitcher of water, right?
Yeah. I mean, I'm not so sure. I think Moses holding the 10 Commandments strikes most people as religious. I think this kind of gets into the issues with this sort of objective observer. Is this endorsing religion? Is this not kind of test? I mean, plaintiffs really want, they've got like a Goldilocks objective observer. It's somebody that doesn't know too much about these statutes in order to know that they are the symbols of firefighters and police officers. Also doesn't know too little.
Well, think about the person who's driving to Roxy's to get their bargain meat, right?
I'm not sure that person knows who these figures are, Your Honor. I think that's kind of
the second one doesn't look religious, right? It looks like a Roman soldier.
It looks like a Roman soldier, Your Honor. And I don't think there's any kind of no angel rule either, right? There's a famous angel in Central Park in New York City. There's an angel in the Boston Public Garden. I think all this discussion gets at kind of the uncertainties of their test. And this is not a question that Colo asked, right? If you look at how Colo approached the effects part of the analysis, or at least what it called that, it didn't ask, would an objective observer view these prayers as endorsing religion? Again, kind of a strange question. Instead, it said, are these prayers likely to meaningfully change people's religious practices? It said no, because this, unlike in a school, right? This is in a legislative chamber. It's not a pedagogical context. It's not a place where the whole point is to influence impressionable school children. I would say that the public safety building is a lot more like a legislative chamber than it is like a school. So if you use Colo's analysis, not necessarily what it invoked as the criteria or the guidelines, which, as Justice Kafker said, were at that time the Lemon test. There was, of course, a federal establishment clause claim in Colo in a way that there's not here. If you use its analysis, that analysis is fully binding. We're comfortable with it, and I think it cuts strongly in favor of the city in this case.
Thank you.
Thank you, Your Honor.
Attorney Rossman.
Good morning, Your Honors. Jesse Rossman on behalf of the appellees. With me at council table are Rachel Davidson and Suzanne Schlossberg. Our Massachusetts Constitution protects the right of private individuals and religious institutions to display religious statues, and they often do so to indicate that a particular building is meant for people of a particular faith. But our Constitution equally prohibits the government from installing new religious statues as the sole adornments on a prominent government building.
Can you give me the intellectual basis or the basis for new versus existing?
Absolutely, Your Honor. And I think this is something that was reflected both in Colo itself, where this court looked to the fact that the long-standing, consistent history of something which existed with legislative prayer and doesn't exist with the statutes at issue here is something that can be taken in consideration. The federal Supreme Court did the same in American Legion, for example, distinguishing between old statues and the new installation of statues, and that might have an impact. And I think that cuts in at least two places, Your Honor, when you're looking at the Colo test. That's both with respect to effect and with respect to divisiveness. So with respect to effect, there may be a different understanding when statues that were erected over 100 years ago, which the vast majority of the statues that the defendants reference in their brief were, what kind of historical meaning that is taken on today that might be something that has become secularized. And I think the Bladensburg cross, I really worked on trying to pronounce it correctly. I thought I was going to get it and I didn't. That cross had been in place for over 100 years, and it had become a site for veteran memorials on a regular basis. And so it had taken on a secular meaning, in part because of the length of time that it had been in that location. And I think another indication, Your Honor, is divisiveness. One of the things that Justice Breyer talked about in the Supreme Court was something's been around for decades at a time and there's been no division. That's something that can be an indication that it's not violating our religious protections clauses. But of course, here we have something that is the decision of the Quincy government today to erect two new statues that, as the unrebutted expert testimony from Professor Byrne makes clear, reflects the specific Catholic iconography of St. Michael the Archangel and St. Florian. And it is certainly something that has caused division prior to the litigation in the city of Quincy. And the record is replete with that evidence. And so we think that the Superior Court was right to determine that the plaintiffs were likely to succeed on their claims here.
The Superior Court does a heavy lemon analysis. It doesn't really look to the rest of Colo, which, I mean, Colo begins with some important points about history and purpose, and then it also talks about, you know, it's concerned about, let me read you this sentence. The long history of a certain practice, however, and its acceptance as an uncontroversial part of our national and state tradition do suggest that we should reflect carefully before striking it down. You know, Colo has a lot of the modern day Supreme Court stuff that, as well as Lemon versus Good, but the trial judge really focuses on the four-part test almost exclusively, doesn't he? And I'm just worried that these symbols have a long-term meaning. I understand this is a new statute, but the symbolism for police and fire has been around a long time. And the Supreme Court's cautioning us not to, that we're, and Colo says the same thing. There's not a hermetically sealed or separation between church and state. Some of it's allowed based on historic traditions and just sort of the way we live in this country and state. So I'm just trying to figure out why this crosses the line when the legislative chaplain one didn't cross the line, when it was also a Catholic chaplain historically in the legislature too. Are you saying that's wrong? Colo's wrong on that point?
No, Your Honor, we think this court got Colo right, and I think it should give this court great comfort, in fact, that the Colo test in that instance ended up upholding the state practice. It's not a toothless test. It's a real ability to analyze the specific fact pattern that's at issue in a given case to determine whether or not it's violating Article 3. And the very criteria and elements that this court looked at in Colo point in the opposite direction when we're talking about the St. Michael the Archangel and St. Florian statues that are at issue in this case. So in Colo, Your Honor, what the court focused on was the fact that these were temporary, these were brief prayers, it was voluntary whether or not individuals were engaged. The state had no role in choosing what the content of the invocation was. And while it was true that the history had shown that over the past 20 years there had been Catholic chaplains, there had also been additional diocesan chaplains, that had come in to present prayers of different denominations during that period of time. It wasn't set in stone. And it also turned in large part, Your Honor, on the unique historical pedigree of legislative prayer, which has been consistent and constant since the founding. Those things cut in the opposite direction
But
when we look at this
statues,
case.
we have a lot of statues in public places with religious elements to it. Massachusetts has a lot of them, right? They do a good job, and I mean, in some of the amicus brief, the police department has an "In God We Trust" on every badge. I mean, we've got all kinds of that out there, and I'm just worried how this fits in with that world.
I think it fits in quite nicely, Your Honor, and I think Colo itself, looking at that history and purpose, which I don't view as a separate part of the test, Your Honor, as I understand reading the decision, the court articulated those principles and then walked through those 4 guidelines of effect, purpose, divisiveness, and entanglement, and considered it within the context both of history and purpose, as well as the current context. And I think there's really significant contextual differences, Your Honor, between many of the statutes that are cited in defendants' briefs and that are right here in the Commonwealth. We look to context. Is it solitary or is it surrounded by other figures that have a secular meaning? Does it have pride of place on the outside?
What are the other figures that have meaning to police officers and firefighters? What other figures would you anticipate would be required in order to make this constitutional?
Well, Your Honor, I think one option could be, I know that there have been many heroic police officers and firefighters that have performed duties here in the Commonwealth and elsewhere.
So if we had St. Michael, St. Florian, and real other people, then that would pass constitutional muster.
I think it would depend on the context, Your Honor, but I actually think that's one of the reasons why the Colo test is so helpful to retain, because as this court said in McDuffie, our constitutional provisions provide general principles. They're not a specification of details. And so lower courts need guidance and a framework to analyze when something violates a constitutional provision. The 4-factor guidelines that Colo provides gives lower courts the ability to do exactly that. And in this instance, the record—
There's been so much criticism of those particular 4 factors, and that we're going to certainly have to take another look at those. Whether those particular factors, there's a lot of, particularly the purpose one, because there's always multiple purposes. So it just seems, are there any cases where we've struck down, any examples where we've struck down something like this? I'm just, because Colo, the most analogous was affirmed. I'm just trying to, good examples where we struck something down, a statute somewhere like this.
So, Your Honor, to my knowledge, I believe that there was Colo, and then this court in 2004 reaffirmed the Colo test in the Society for Jesus case. but there hasn't been applications of COLO since. And that makes sense. If you look at states throughout the country, many religious freedoms cases had been brought in federal court and not in the state court system until recently. But I encourage the court, the COLO test is workable, and the Borgman amicus speaks to that. And the mere fact that the Supreme Court is either unable or unwilling to faithfully apply it doesn't change the ability of this court and the other courts in the Commonwealth from being able to do so. And in fact, this court has a pedigree of continuing to retain workable tests.
How do we determine if there's a secular legislative purpose?
So, Your Honor, I think in this case, even taking, and I know we've had some discussion about whether or not the Superior Court credited the mayor's statement, even taking the mayor's statement at face value, because as this unrebutted expert testimony in the record below show, the purpose, the inspirational power of these two statutes is inextricably intertwined with its religious underpinning. And that's not just from the plaintiff's own expert testimony. It's also, I'm sorry, Justice.
No, please, I want you to finish.
It's not just from our plaintiff's own expert testimony, which is unrebutted, and I will say that was the record before the Superior Court, not the amicus briefs that have been filed before this court, but it's the defendant's own exhibits that were before the Superior Court itself, which time and again reference the religious roots and the power of prayer when they're talking about the inspirational value of St. Michael and St. Florian. So there may be closer cases, and I think Justice Kafka, you had mentioned in the Kaplan case that in these kinds of analysis, there is line drawing, and that line drawing is sometimes difficult, but it's also necessary. And the advantage of the COLO test is it gives a framework for that to be able to apply.
So you spoke of other factual records in other cases, but we're obviously at a very preliminary stage of this case. So would you concede that if this case, obviously will go back down one way or the other, and if Quincy built a huge factual record showing well beyond anything we've seen here that, these Florian and Michael are essentially the mascots in kind of a sports team way of police and firefighters all across the country of every different religion, and it's not just about prayer, but it's just this encouraging symbol like gritty or whatever, that would be enough? Or are you saying that the well is poisoned because they originally came from a religious tradition?
I think what we're saying, Your Honor, is that this record supports the preliminary injunction.
I'm not asking about this record. I'm asking about, you said that in another case, there could be a showing that a religious symbol had taken on a secular meaning. And I'm not asking you about the record before us, which I understand we are constrained to, but my question is, these particular symbols, Florian, Michael, St. Florian, St. Michael, is your position that there's no possibility of building a record about their meaning in the police and firefighter community that could ever win under COLO?
Your Honor, we would of course have to take that record as it comes, and I do think again that COLO provides a helpful framework to be able to do so. There is already an existing record right now, which would have to be a part of that, of course, but I take Your Honor to be saying outside of that. So all we are asking this court to do today is essentially two things, and that's to reaffirm the test that has already been in place for 50 years, and to, on this record, determine that the preliminary injunction needs to stand.
Can I go back? I'm sorry. So a couple of moments ago when you were answering Justice Wendland's question, something jumped out. Are you localizing this to the Catholic faith specifically? Because you keep saying religious affiliation, and we have here, the record is clear that this is important to Jewish traditions, Muslim traditions, several different Christian traditions. And so are you saying that we should, how are you saying we should treat these statues as specifically being Catholic or more broadly, something more general?
So I think there are two important answers to your question, Your Honor. First, as Justice Wolohojian said earlier, adding more religion to these statues does not remove the Article 3 problem.
Why not? Because Article 3 specifically says no subordination of any one sect or denomination to another. So the fact that multiple sects find this symbolic does seem relevant, at least, to the Article 3 inquiry.
Well, I think the text of Article 3, Your Honor, encompasses a general principle of government neutrality and not raising one religious beliefs or religion in general above non-religious beliefs. And even if there were 3, 4, 5 religions that found these figures to be important, that would still be elevating religion over non-religious beliefs. But I think an important second piece of the answer, Justice Georges, to your question, is the unrebutted expert testimony from Professor Byrne that these particular statues encompass the Catholic iconography of St. Michael and St. Florian. Professor Byrne also talks about the fact that other religious faiths, like Judaism, do not have saints. So they might be figures in their religion, but St. Michael, the archangel, and St. Florian, as they are depicted on this building, directly reflect the Catholic iconography. And I want to be clear, if there was a statue that directly reflected another religion, if there were 2 10-foot tall Jewish stars or 2 10-foot tall moon and crescent and stars that were outside the building, it would pose the same issue.
Well, but that goes to the bigger problem, because I'm trying to figure out what the framing is here as to what you think the Article 3 complaint here is. So is it that it prohibits endorsement generally? Is it that it prohibits denominational preference specifically, or legal operational subordination? You've touched on all of these, but what's the complaint here with these particular statues? Which is it?
These statues, Your Honor, are conveying a message that a particular religion is being elevated above other religious and non-religious beliefs. Now, I do think that the Article 3 language about non-subordination and the Equal Protection Clause encompasses a comprehensive notion of government neutrality towards religion. It doesn't require a hermetic ceiling.
Can I push on that point a little? Because, and again, I'm reading from Colo, because Colo, again, it anticipates some of the stuff the Supreme Court started moving to. I'm reading, rather, it studiously defines the manner, the specific ways in which there shall be no concert or union or blanket. That is the common sense of the matter. Otherwise, the state and religion would be aliens to each other, hostile, suspicious, and unfriendly. The U.S. Supreme Court is really concerned about government action that appears to be hostile to religion. And I'm trying to understand, they could put up statues of almost anything in that building, right? And they can't put these up. And I'm just wondering if that runs into because we can't provide less protection than the Supreme Court on free exercise, or, we can't allow more hostility to religion than the Supreme Court would tolerate, and they have very low tolerance. I'm trying to understand, if you could put up any kind of statue in this building, but you can't put up these ones that have a religious element to it, is the Supreme Court going to be troubled that that's singling out religion somehow in a way that's inappropriate?
I want to be very clear on the record, Your Honor, because I know this is something that opposing counsel has raised. There is no potential violation that is of federal law that is posed by the relief the plaintiffs are seeking here.
Can you talk a little louder? You're very tall and that microphone's
sorry, I'm wearing heels too, so I think that's adding to it. I think there are 2 different elements. I apologize, Your Honor, if it gets too quiet again, let me know. There are 2 different elements that I want to address, both the free exercise issue and then this general notion of hostility towards religion, which I take the opposing counsel to be referring to the Establishment Clause and not the free exercise.
Well, the Supreme Court, some of the amicus briefs are straying. They're saying there's going to be an overarching sensitivity to hostility to religion. And the U.S. Supreme Court, again, its more recent jurisprudence is very focused on that.
It is, Your Honor, and the context in which that has arisen is critically different from what we're talking about here. So free exercise clause concerns come into play when the government is burdening private individuals or private institutions.
It's preventing grants, for example. The grants are the classic example, right? State-funded funding, if the state is willing to fund everything else but not religious exercise, that crosses. That's the Supreme Court revised its jurisprudence to sort of focus on that, right?
It did, Your Honor, in the Espinoza case, and it talked about the fact that if other private institutions were going to get access to those grants, then religious private institutions also had to have similar access to the grants. But that's not the case at issue here. There is no private individual. That's part of the problem.
Right,
this is government speech, and it's the government using its platform to elevate a religious belief over the other beliefs of others. So I think squarely within what the court has said in Espinoza, in Masterpiece, in Kennedy, this does not run afoul of those principles. With respect to this blurring of the lines on hostility towards religion, Your Honor, I want to be very clear as well. Their neutrality, government neutrality towards religion is not the same as hostility towards religion. And this court need look no further. You mentioned the Supreme Court. The Supreme Court just last year said as much in the Catholic Charities case, where the court held the fullest realization of true religious liberty requires that government refrain from favoritism amongst sects. And we know through our practice and through the amicus briefs that have been submitted that government neutrality towards religion increases religious pluralism within a society and the ability to practice your own faith. And what the defendants are arguing for here would really torture the English language and twist Article 3's principles so it almost cannibalizes itself. Nothing that the U.S. Supreme Court has held requires that.
It seems to be, though, also is from whose perspective? Because if you're taking the perspective of the amici, particularly the firefighters and the police, I would presume that there's a heck of a whole lot of, they might be agnostics, there might be atheists, there might be Catholics, there might be Jews that serve on the police and fire in Quincy who are very much in favor of the fact that this has some professional meaning to them of their safety and guarding what they do. And so it seems to me to bring up the point that Justice Gaziano made a little while ago about the guy going to Roxy because brisket's on sale. Like, I mean, are we going to turn these constitutional kind of questions into kind of, I don't know, a heckler's veto?
Absolutely not, Your Honor. I think that's partially, though, why, again, the Colo test of looking at effect, looking at purpose, looking at divisiveness and entanglement on the record. And the record here shows that these are both religious messages. They're being received as religious messages. The Quincy Interfaith Alliance, which was 19 different faith leaders in Quincy, held the same. And again, the defendant's own records, I encourage the court to look at exhibits 4 through 15, where repeatedly the defendant's own exhibits reference the religious roots and the power of prayer that lead to the inspiration. There may be, it is not that someone who happens to be religious can never have a statue erected on a piece of government property. That's not the test. And that's not what the plaintiffs are asking for here, where you have 2 Catholic saints whose images match the specific Catholic iconography, whose power to inspire is directly connected to Catholic doctrine, and who are on the outside of a building that is meant to be welcoming and to ensure that people have equal access to the public safety services. That violates Article 3. And that's all we're asking the court to hold here.
Okay, thank you.